Welcome to another episode of JurisQuestHub. I'm your host, Cynthia Liavule, a lawyer and advocate of the High Court of Kenya by training and profession, a teacher at heart, and lover of philosophy of law. Before we get started, please consider subscribing to JurisQuestHub. Your support will enable us to continue providing valuable content on jurisprudence, basically the philosophy of law, and legal theory. Now let's get started with today's episode. This episode focuses on the relevance of the Speluncean hypothetical case to modern law. From our previous episode, we learned that the approaches and decisions by the 5 judges in the Speluncean case exemplify differences in understanding the nature and essence of the law, methods of interpretation of the law, the dilemma and debate of law and morality, the defense of necessity, and the boundary of statutory interpretation by the judiciary. These issues remain relevant and evident in the practice of law today, and therefore the Speluncean case, even though hypothetical, provides a timeless analytical tool for discourse on the nature of law, its application, its interpretation, in unprecedented situations, and in modern law, especially with new technological advances and innovations. Some of the themes that come out in the Speluncean case and are still relevant today include what law is and what it seeks to achieve, how legal rules should be interpreted, how morality interacts with legality, the extent of the exercise of judicial authority and judicial authority in emerging areas of law outside the traditional and strict provisions of the law. So first, let's look at the Speluncean case insofar as the role of legal theory is in shaping legal justice systems. Legal theory, which we shall keep looking at in the following episodes, basically defines the nature and the essence of law, its purpose, its sources, and the principles of application. From the Speluncean case, we see Chief Justice Trupeni, who embodies legal formalism, applying statutes exactly as enacted, while relying on executive clemency to soften harsh results. Modern systems influenced by this way of thinking will therefore emphasize consistency, textual fidelity, and separation of powers, with humanitarian adjustments delegated to pardon authorities rather than courts. Justice Foster, on the other hand, advances a more natural law perspective, arguing that the purpose and the moral foundations of the law must guide judicial interpretation. Today, this approach of law would support rights promotion jurisprudence, for example, in constitutional democracies, and as such would encourage judges, for example, to prioritize issues of justice, human dignity, and purposive reasoning, especially in exceptional cases or life or death scenarios. For Justice Tutting, he personifies the internal conflict of strict positivism when confronted with moral dilemmas. His withdrawal from the case also shows the importance of acknowledging that in some instances there is often judicial uncertainty, and it legitimizes what we call judicial recursal when a judge cannot reconcile his legal reasoning and ethical obligations, and therefore this contributes to modern practice in terms of transparent judicial ethics. Justice Keane, on the other hand, reflects uncompromising legal positivism and textualism. He insists that judges apply the law without regard to their personal moral views. So he reinforces the primacy of the legislature. And a legal justice system shaped by this philosophy would focus on the clarity of the law, judicial restraint, and predictable application of statutes, even when the outcomes are very severe or have very dire consequences. Lastly, Justice Handy promotes legal realism, urging judges to adopt common sense reasoning and consider real-world experiences and consequences, as well as public opinion. A justice system that is influenced by this way of reasoning would therefore incorporate pragmatic policy in terms of analysis, the social context, and democratic responsiveness into their judgments. So together, these 5 perspectives illustrate the enduring intellectual tensions in modern legal justice system, where we have strict and purposive interpretation, where we have the dilemma of morality versus legality, as well as the boundaries of judicial discretion, and the dynamic interplay among different branches of the government, that is the executive, the judiciary, and the legislature. And this in turn contributes to a very enriching way of navigating the complexities that are posed by law, morality, and justice. And most importantly, they also show the different limitations of the legal theories, especially when they are applied in isolation, and the consequences, which, as we have seen in the Speluncean case, are very evident in the outcomes that each of the judges comes up with. Secondly, another aspect of modern law, insofar as the Speluncean case is concerned, is its impact on the models of interpretation of the law. To date, there is considerable debate in both the formulation and interpretation of the law, either as strict or absolute, or in a purposive way. By presenting a single set of facts and one applicable statute, the case shows how judges, depending on their legal jurisprudence and theory, may reach entirely different conclusions on the same case. And from this, we see that legal interpretation is not a mechanical application of statutory text or legislation, but a process that requires reasoning grounded in jurisprudential principles. So the case emphasizes several key themes. First of all, it really brings out the limitations of strict textualism, where the law is taken literally, and some of the absurd outcomes that the law is bound to have when it's taken without the regard for common sense, for morality, and even the intention of the lawmakers sometimes. Second, it also reveals the importance of the context, purpose, and moral reasoning in situations where the law does not anticipate extreme or unusual circumstances. I will revert to this in the last part of today's episode. And thirdly, the case highlights the ongoing tension between judicial restraint and judicial activism, and illustrates how some judges apply the law exactly as written, while others interpret it through a broader spectrum, social, moral, pragmatic considerations. And from this, we see that the Speluncean case demonstrates that interpretation is a complex, it's value-laden, and it continues to shape discussions about how judges should read, apply, and understand the law in modern legal systems. Are you a law student, a legal practitioner, a drafter, a judicial officer, or someone with a lot of interest in the law? What approach has been enriching when interpreting and advising on various legal issues you encounter? The third aspect is law and morality, the law and morality debate. The Speluncean case underscores the inherent limitations a purely literal or positivist reading of legislation, particularly when such approach leads to outcomes that conflict with principles of fairness, human dignity, or societal values is concerned. And this highlights a central issue in modern law, morality debate, where judges are expected sometimes to strictly adhere to legislative text or to allow moral or purposive considerations to inform their decisions when the law appears either inadequate or unjust. The contrasting judicial stances in the case mirror ongoing debates within real legal systems about the permissible scope of moral reasoning in adjudication. And this is evident in modern law, for example, in emerging areas such as digital ethics, bioethics, and the formulation of new rights. So there's difficulty in reconciling the dictates of statute, especially if the essence of the law is considered from a positivist approach and not what is morally just. The dynamics that relate to the necessity, the defense of necessity in the Speluncean case are still applicable in terms of the law and morality debate, especially in instances such as regard for the death penalty in criminal cases that involve issues such as murder. And then one of the most important issues as regard the Speluncean case that is evident today is the exercise of judicial authority and discretion. So here we have restraint versus activism. The different judicial opinions by the 5 judges highlight the ongoing debate about the proper role of judges, whether they should apply the law as written, which is judicial restraint, or use their discretion to achieve a just outcome, and therefore potentially consider public opinion, executive clemency. In the recent past, however, there's been discourse notably within the European Union on the legislative authority of judges, who have sometimes been accused of overstepping their mandate through their decisions. And this is because the outcomes have been the creation of laws within the EU which contravene, for example, the doctrine of state sovereignty and legislative authority of their respective parliaments. This was evident in an interesting case, which you could later look at, Costa versus Enel, which raised concerns about the overriding national sovereignty principle. Similarly, in Kenya, the courts have taken an active role in constitutional matters, and one of the notable cases was the annulment of the presidential election held in 2017, which upheld electoral integrity and sparked debates on judicial overreach. And my favorite part of the application of the Speluncean case has to be in emerging areas of law. The case of the Speluncean Explorers continues to offer a foundational framework for grasping and interpreting legal and moral challenges posed by emerging areas of law, where established rules may be inadequate to address novel or complex situations. And here, the core tension usually is between the strict adherence to legal texts and the necessity of the contextual, moral, informed judgment that are evident in modern law. And this is coupled today with a lot of technology, environmental crises, and even governance in extreme circumstances. Some of these examples include artificial intelligence and autonomous systems. There are many ethical and legal challenges arising from AI, such as autonomous vehicles and decision-making, algorithms, and AI developers, for example, must program machines to respond to unforeseen or tragic scenarios or accidents. And usually the debate within cases is often about the judicial discretion versus strict statutory interpretation. But most importantly, the question often is on the liability, especially where there are accidents or unforeseen incidents arising from the use of artificial intelligence and autonomous systems. So the Speluncean case emphasizes the need for clear and reasoned judicial opinions, which are very parallel. For example, for the need of transparency, accountability, and liability, for example, in AI decision-making, when these decisions carry significant moral or legal consequences. Another sphere would be extreme environments and the cause of jurisdiction. So the predicament of the explorers who are trapped in the remote cave beyond the reach of ordinary law parallels the challenges of regulating activities in extreme environments. These include outer space, deep sea territories, questions of jurisdiction directly comparable to those raised by Justice Foster's argument that the explorers were effectively removed from their usual legal order continue to arise. And therefore, with modern law, there's an expanded frontier, and application of legal systems must be alive to these new scenarios, new jurisdictions that go beyond traditional territories or jurisdictional concepts, which sometimes are insufficient. And sometimes survival in such instances may compel actions that conflict with established laws. The Speluncean case thus provides available templates, so to speak, for analyzing and developing legal frameworks that balance strict legality with the practical necessities of extraordinary environments. And lastly, another emerging area of law where the Speluncean case could be applicable is on matters related to climate justice and resource scarcity. And this has posed a lot of legal challenges, especially in the allocation of limited resources, as well as governance and civil obedience, especially in emergency situation. So we see that the necessity of defense in the Speluncean case resonates a lot with modern legal debates surrounding actions that should be taken to prevent greater harm, especially during environmental crises. So the case encourages legal systems to move beyond rigid statutory interpretations and adopt adaptable, context-sensitive, context-specific frameworks that are capable of addressing the moral and practical complexities of sustaining society amid existential threats. And by emphasizing principled discretion and purposive reasoning, the Speluncean hypothetical case helps in framing legal responses, especially in urgent matters, large-scale crises, and instances where the current laws may not have anticipated the issues. So in summary, the Speluncean case is timeless. It has timeless lessons, and we have timeless lessons from the cave. It remains a foundational reference in both legal education and practical jurisprudence, illustrating the enduring tension of strict adherence to statutory law and the necessity of moral and contextual reasoning. The divergent opinions of the 5 judges highlight the multiple ways in which jurisprudence, which is basically the philosophy of law, legal theory, and ethical consideration, intersect in shaping judicial outcomes. For modern legal systems, this provides a practical framework for navigating situations where laws may be ambiguous, may be outdated, or is suited to extraordinary circumstances. And therefore, ultimately, the Speluncean case encourages a legal practice that is both principled and flexible, one that emphasizes transparency, ethical reasoning, accountability, and it's also a reminder to judges, lawmakers, legal practitioners that they need to assess the interplay between law, morality, and social consequences, ensuring that our legal systems or whatever laws we develop remain robust, just, and responsive to the evolving challenges of modern society. And by bridging theory and practice, the Speluncean hypothetical case therefore remains an indispensable tool for fostering thoughtful and socially responsive legal practice. Thank you for your time. If you enjoyed this episode, don't forget to like, subscribe, and ring the bell. You won't want to miss the next episode. See you in the next one.